You know what really grabs me? It's when a story feels like it's not finished, like there's more digging to do.
Yeah, I know what you
And
mean.
that's exactly the vibe I got from the material you sent over about the RBC retrenchment case.
Hmm.
It feels like we almost need to, I don't know, rewrite the history a bit
Mm-hmm.
to really get a handle on who was legally to blame for, you know, all the issues with filings, the misrepresentations, the procedural stuff that came later.
Right after the initial tribunal decision.
Exactly. So that's our mission today in this deep dive. We're looking at this report in defense of the Special Tribunal. It's by Victor Sandy, dated April 2025.
A very recent analysis then.
Yeah, and it's aiming to, quote, correct the legal record. So the big question we're tackling is, after that first special tribunal ruling, who is actually, legally speaking, responsible for all the subsequent problems?
It's a crucial question, because the common narrative might be a bit too simple. Sandy's report really challenges us to look at the sequence of events and the specific legal roles involved after that 2018 decision.
Okay, so let's start where most people probably remember it. The Privy Council eventually looked at the Special Tribunal's initial ruling, and they weren't impressed.
Right. Not at all. The report acknowledges this straight up. They called the tribunal's dismissal manifestly bad in law. Pretty strong language.
Yeah, it sounds like the tribunal really messed up there. Case closed, blame assigned.
Well, that's the knee-jerk reaction, isn't it? But Sandy's report immediately pushes back on that. The core argument is, okay, the initial ruling was criticized, but that doesn't automatically make the tribunal liable for everything that happened afterwards.
How does that work? If your first decision is overturned so harshly, aren't you still involved somehow?
Legally, not necessarily. And this is maybe the most critical point the report raises, the concept of functus officio.
Functus? What now?
Functus officio. It basically means the authority's task is done. Once a tribunal like this makes its final decision, its job is over regarding that specific matter. It generally doesn't have the power to revisit it or, crucially, to actively participate in appeals.
Ah, okay. So, like, they issue the ruling, and then hands off.
Pretty much. The report cites legal authorities to back this up, cases like Marquis v. Police Service Commission here in TNT, and well-known texts like Wade and Forsyth on administrative law. They all support this idea.
So the argument is the tribunal made its call in 2018, and legally, that was it for them. They couldn't step back in.
That's the essence of it. According to this legal principle in Sandy's report, their function was complete. Any subsequent legal actions, filings, arguments in higher courts, that responsibility legally shifted elsewhere.
Okay, that is a big shift in perspective. Because honestly, I think many people, myself included, sort of assumed the tribunal was defending its initial decision through the Court of Appeal and the Privy Council stages.
And the report directly tackles that assumption. It calls it a false attribution. Sandy argues that any idea the tribunal was actively fighting the appeal is just wrong. They weren't even a party to the appeal.
They weren't a party. So who was arguing the case then?
The state. Represented by the Solicitor General of Trinidad and Tobago. They were the ones handling the appeals, filing the documents, making the arguments, not the tribunal.
Right. Okay. Now, this report gets into some specifics about those arguments, doesn't it? Something about a branch board.
Yes. This is fascinating. Apparently, during the Court of Appeal stage, the State Council argued that the reason the tribunal had initially dismissed the case was because the EPA, the Estate Police Association, didn't have a properly functioning branch board.
Okay. And the report says...
The report says, hold on, the tribunal never actually gave that reason in its written ruling. Sandy states the tribunal's oral ruling was based on something else entirely. This branch board excuse, the report claims, first popped up in the written submissions filed by the Solicitor General's office for the appeal.
Wait a minute. So the state's lawyers might have introduced a completely different reason for the tribunal's decision when they went to the Court of Appeal.
That's the bombshell allegation in the report, yes. That the justification defended in the higher courts wasn't the one the tribunal originally gave, at least not in writing.
Wow. So this whole narrative that you sometimes hear that the case failed at the tribunal because of this internal EPA issue, and that doomed it from the start.
Might be built on a shaky foundation, according to Sandy. The report argues the actual reasons given by the tribunal got lost, or perhaps deliberately omitted later on.
And the report counters the idea that the case never recovered after the tribunal.
Exactly. It argues that subsequent failures, like potentially the EPA not filing for judicial review properly or on time, and the Solicitor General continuing to defend this allegedly false branch board premise, Those are separate issues that happened after the tribunal was, legally speaking, out of the picture.
So if the tribunal is off the hook for everything post-2018, according to this report, then who does it say is legally responsible? This is where we get back to that core question of blame, right?
Absolutely. The report doesn't shy away from naming names or offices. It provides a pretty clear breakdown.
Okay, let's hear it. Who's on the list?
Well, first, for the alleged failure to appeal the initial ruling within the lawful time frame, the report points to the EPA itself, specifically naming Harrison Thompson and Robert Ramitar.
Okay, so that's on the association side. What about the state's actions, the filings, the arguments?
For inserting that allegedly false branch board claim into the proceedings, the Solicitor General of Trinidad and Tobago.
And for filing the case up to the Privy Council, apparently without a proper legal basis, according to the report.
Again, the Solicitor General.
What about the missing information, like the transcript of the tribunal's actual ruling or the true reason they gave?
The report assigns responsibility for omitting that crucial context to both the Solicitor General and any external legal counsel the state hired.
So a shared responsibility there. And for sticking with the branch board argument throughout the appeals.
Solicitor General, again, is the conclusion in the report. It argues they continued to defend grounds that were, based on Sandy's analysis, false.
It really sounds like this report is systematically dismantling the idea of tribunal responsibility for anything after the initial dismissal.
That's definitely the objective. It keeps coming back to Functus Officio and the legal framework. It emphasizes that under the rules, the civil proceedings rules, the Constitution, only the Solicitor General has the authority to defend the state in the higher courts once the tribunal has ruled.
So the tribunal literally couldn't have been running the defense in the appeal courts, even if they wanted to.
Legally, no, not according to this interpretation. Their role was finished. The reins were passed to the Solicitor General.
So, wrapping this part up, the report essentially says, yes, the Privy Council slammed the initial ruling. Fine. But don't blame this special tribunal for the alleged mess that followed the dodgy filings, the misrepresentations, the missing transcript, arguing the wrong points.
Precisely. Sandy's conclusion is that the tribunal didn't defend itself, didn't invent new arguments, and bears zero legal responsibility for how the case was handled in the Court of Appeal and the Privy Council.
And that responsibility, according to this report, falls squarely
on a Solicitor General's office as the legal representatives of the state, and on the ETA for that specific alleged timing failure with their own appeal efforts.
So going back to that initial feeling, that need to maybe rewrite the history of this case to understand who was legally accountable after 2018, this report offers a very different script.
It absolutely does. It directs the spotlight away from the Special Tribunal and firmly onto the actions, or alleged inactions, of the Solicitor General's office and parts of the EPA leadership at the time.
It reframes the whole post-2018 saga, suggesting the legal blame lies with the active legal officers who perpetuated the deception, as the report puts it.
That's the strong claim being made, yes. It's an attempt to correct the record from the tribunal's perspective.
Okay, so the key takeaway from this deep dive, based purely on Victor Sandy's report, is that the legal responsibility for the alleged problems in the RBC retrenchment case shifted entirely away from the Special Tribunal after it issued its initial ruling. It landed with the Solicitor General's office and the EPA.
That's the argument in a nutshell, a fundamental shift in accountability.
So here's something to really chew on as you think about all this. What does it mean for our understanding of justice and accountability if the commonly accepted narrative of a complex legal case might actually misplace the legal blame?
That's a powerful question.
And how critical is it when you're trying to understand who's responsible to really scrutinize the timeline, the procedures, and crucially, who had the legal authority to act at each specific stage? This report certainly suggests it's paramount. Definitely gives you a lot to consider.